failing to state cause of action, lack of jurisdiction both subject matter and against the individuals.
Before we go there, any indication why this individual has opted to not appear? Have you talked with this person? Do you have any idea?
He's been posting quite vigorously that he couldn't be here.
And I would like to speak with him about that. But he's not here to do that. But you have not any indication of why he is opted not to not appear? So also it appears that subpoena has been issued in this case, Mr. Skordas. Have you seen that? Looks like on the 11th, there was a subpoena that was issued by Mr. Greer to a, am I on the right case here? 7268? Yes. To a Sam Harkness, General Counsel of Larry H. Moore Sports Entertainment. Does not look like he was served upon. That's news to you?
Yes.
Do I have Mr. Harkness here by chance? That's okay. I have no indication of his served.
He's their attorney. The deaths are alleged to have occurred.
Yeah.
I would ask the clerk to grant our motion to dismiss.
The record is very interested in discussing Mr. Greer's social media activity for any of those in the, anyone else may be listening. And for the record, those possibly constituted electronics, communications, harassment, even possibly misdemeanor, if not felonious stalking. Excuse me, sir?
Including members of my own family.
But I don't want you to have to come back, Mr. Skordas, because I would consider issuing a warrant for Mr. Greer to come and talk with us about these things. But I don't imagine that that's something that you're seeking at the moment, sir. All right. What kind of fees have you incurred for this kind of representation?
We put a cap on our fees of $2,500. I don't think we hit that yet. Whatever you think is reasonable.
Thank you. I will grant the motion of dismissing this case with prejudice. You see no reason, no filing, nothing to the effect of Mr. Greer not appearing on this case, causing the defendants to incur a significant amount of attorney's fees, time, I would imagine stress, apparently for either a nefarious purpose or otherwise, coupled with some of the other inappropriate social media activity. Facebook's not just for fun. If you want to threaten someone on Facebook, it's like you said it to their face. And when you talk about blood in the courtroom, we don't take that lightly, just in case any of you are curious about that. Right, Mr. Skordas?
Yes.
I am dismissing that Mr. Greer's claims with prejudice, awarding $1,500 of attorney's fees to the defendants to be reduced to judgment. Anything else on that case I can do for you, Mr. Skordas?
Sorry, Your Honor. Thank you very much.
Very good, thank you very much.
Are we excused?
Please, thank you very much. Thanks for being here today. I'm sorry that it seems to have been a waste of time. All right, ladies and gentlemen, I don't imagine that any of my other cases will be making my ire raise like that, sir. Well, good. Then let's have a conversation. Yes, Your Honor. Full court remains that. We're going to do some here. You going to get through yet?
Yes, Your Honor, exactly.
Mr. Greer?
Yeah.
Come on up here. Court started 35 minutes ago. Raise your right hand to be sworn in.
Do you solemnly affirm the testimony you're about to give in this matter be the whole truth and nothing but the truth under the pains and penalties of perjury?
Yes, sir.
Take a seat at one of the tables, Mr. Greer. May I inquire, Mr. Greer, about your tardiness today?
I thought it was at 2 o'clock.
Why would you think that?
And I must have read my calendar wrong. I have, if I can put it on the phone.
I'm not gonna look at your phone, and I don't really care what's in your phone tonight. I'm looking at a small claims affidavit and summons that was completed by you, correct?
I guess so.
It states pretty clearly on August 2nd, 2017, at 1:30 p.m. is when we are going to be having our hearing. You've had individuals here, witnesses here, attorneys here, and full court staff here waiting for you. If the case is going to be here at 1:30, make sure you're here at 1:30.
And I sincerely apologize.
All right, we already made a ruling on your case, but I have now stricken that ruling since I was told by our fine staff that you had just walked in. I have read through your affidavit and summons, and as you are aware, a motion to dismiss your case has been filed, and was so filed back on June 30th of this year. You're aware of that?
Yeah.
Okay. Saw no response from you. Mr. Skordas, before I go into any merits of this case, why don't you discuss with the court reasoning and the tenets behind your motion to dismiss, please?
Your Honor, the complaint here doesn't say that the claim for relief that this court can grant, even if you believe anything this man says, which I think would be very difficult. There's nothing that would establish a cause of action here. Furthermore, Your Honor, there is no jurisdiction involved with respect to the persons or to the cause. It appears that he went to some sort of concert and felt that he was somehow neglected by one of our clients. I don't know how he gets any jurisdiction whatsoever with respect to the other, who was their agent, except for what he described as some sort of respondent superior. I think this case is filed in bad faith. It's a pattern with this gentleman. We were here some time ago on another case involving another performer. That judge made a very quick order of this. I know that that's not race judicata by any means, but I do want the court to know that this man has a habit of bringing inappropriate and bad faith actions before this court. And there's nothing in his complaint that would support a cause of action.
Very good, Mr. Skordas. Obviously, a bad faith, or shall I say, a bad faith claim regarding has a couple of elements. One, as I recall, is it being non-meritorious, and one without any grounds or jurisdiction. Your proper testimony of your client that both of those are present in this case.
Yes, sir.
And has your client incurred attorney's fees and other costs because of this lawsuit? Would you be requesting an award of attorney's fees because of that?
Yes, Your Honor.
Very much. Mr. Greer, would you like to respond to Mr. Skordas and the defendant's request to the court to dismiss the case that you brought? Prior to that, Mr. Greer, I'd like to address something with you. I've read through your documentation. I've gone through the defendant's documents. I've also been made aware of certain other comments, social media comments, other things of that nature directed at various individuals. I am going to give you an opportunity to explain some of those comments made very recently to me before I take any action on those. Go ahead. This isn't about the case, this isn't about a concert, this isn't about songs, this isn't about anything. This is about social media content, threats, electronic communications harassment, other types of improper, inappropriate, quite illegal activity. And prior to me making a commentary or acting on that, I'd like to hear what you may have to say in defense of some of the things that I have seen, some of the things I have read.
I would like to say that I have a lot of stuff I post online is being sarcastic.
Sarcastic. Are
And
you joking around?
to be honest, I'm not sure what comments you're talking about.
You want me to read some of them?
I'm not really sure.
Okay. Did you mean this? I promise you there will be blood? Sarcastically?
So that's the name of the movie. There Will Be Blood. So I was joking around with that, and I post trolling stuff on my Facebook.
Might you understand that when a stream of discussions are occurring regarding a problem with another individual that may make it to a court setting with judges and bailiffs and clerks and members of society, that when someone says something to the effect that I promise you there will be blood, that might be taken more seriously than the term or the title of a movie? Might you understand that?
Yeah, but that was never part of my, I never really associated that with my court case. I say stupid stuff, and I have talked to several people.
So hang on, when I'm reading, so here is the updated docket of the case. This, I promise you, there will be, you aren't associating this with the case at all?
I wasn't associated with any threat whatsoever. I was saying something stupid. I was being showy. I have over 1,000 followers on Facebook.
I don't care, sir. I don't care how many followers you have. Maybe that makes your crime worse.
So,
Okay, understand, that is improper. That's illegal. If anything, it's electronic communications harassment. It might be misdemeanor stalking. Okay? That's when people get arrested in court for making those kind of comments. You understand that?
And I feel so stupid. I didn't.
Okay, well, I'm not here to make you feel stupid. I'm here to make you feel anyway. Well, maybe I am. Maybe not in this courtroom, not in this courthouse, and my advice would be not in any. Okay? Because these gentlemen don't take that lightly. Okay? Because if there's going to be something that happens, they don't take that very lightly at all. Okay? So you might want to watch Facebook might be fun, might be sarcastic, hee. We take this stuff seriously. Okay? When people bring this stuff to our attention, then we have to have certain people here. That's something that you should take very seriously. You might be spending the rest of the weekend in a cement room. Why shouldn't I dismiss this case based on the discussion that Mr. Skordas and I just had about jurisdiction, not only subject matter jurisdiction, but personal jurisdiction, and for a cause of action or a claim that I can't really put my finger down on? Why should the court not dismiss this and maybe even find it being filed in bad faith and award the fees, sir?
I filed it.
You did what?
I filed it on good faith.
Well, I understand that. Good faith or bad faith is a term, it's subjective. It's not something in your mind that, hey, I think this is good faith, I'm going to do it. The law has a certain criteria whether something is bad faith or good faith. Bad faith means it's done with ulterior purposes, it's not done with any merit, and that the person who brings that case knows or should know of that. So tell me what meritorious purpose this lawsuit has to be filed in this court today.
On March 21st, 2017, I went to a concert at the Energy Solutions Arena.
I'm going to stop you for 1 second. I'm going to listen to all that. What I want to do is I'm going to ask you what cause of action, what thing happened. Causes of action are like assault, or like trespassing, or like negligence, or electronics communications harassment. Those are called causes of action, okay? So I want you to start with, what cause of action do you think the defendants did to you? And then I'm going to listen to your facts and see if they match up at all with your cause of action. Because I can't put my finger on a cause of action. I can't put my finger on what law, what complaint you have that has some legal basis.
Negligence per se.
Negligence per se. Tell me what negligence per se means to you.
And from what I have read in the court books, negligence per se means a law that protects a group of people was violated by some kind. I was a person with a disability. I was harassed. I was laughed at. I felt threatened for my life. At a concert, I paid $900 to $1,000 to go to. The ticket backstage was $500. The concert the show was $300. Add a cost of that, about $950.
Okay, was this something that you believe happened purposefully?
Yes.
Okay, but negligence means it's accidental.
Well-
Negligence means someone had a duty to do something, they didn't do something, accidentally, they caused some damage. So, like this morning, believe it or not, I wasn't supposed to run into the car in front of me.
Yeah.
Literally. And luckily, he just had a great big old ball thing in the back there. My Mercedes now has a hole about that big. So, I wasn't supposed to do that. I didn't mean to, but I had a duty not to. I breached my duty. I caused some damage. Now, if I hurt his trailer hitch ball, I would have owed him some money, but I didn't. Okay? So that's an accidental thing. If you're talking about someone purposely punched me, or I purposely ran into the back of my ex-wife's car, or something like that, then we have a problem. So I don't know if you mean negligence then. You mean harassment?
So I said negligence on the part of Skordas and Ariana because they had a duty to make sure that people under them did not harass people with disabilities. I was citing Utah state law that says a person with a disability has equal rights to advantages, places of amusement.
Certainly. So you're stating that you were denied some of those equal access rights?
Yes, and I was saying that under the duties that things back up, I talked to federal counsel.
I don't care who you talk to. If you want to bring up counsel, or if you're going to bring up the hearsay of discussing with attorneys, then you should run an attorney with you. So either you make the statements on your own accord, or don't bring up other attorneys.
Well, actually, I have the evidence right here, sir.
I'm not going to read through a booklet of Utah law, sir. I know the law that we're talking about.
It's an email I got from federal counsel.
I'm not going to read through the email that we received from another attorney. Let's go to maybe perhaps a more dispositive issue, sir. There's something called jurisdiction.
Yeah.
Okay, you can't just sue someone anywhere you want. You have to have certain reasons to be able to sue them in certain places. Okay, there's something called subject matter jurisdiction, there's something called personal jurisdiction. Maybe to their names, one of them is about the subject itself. The other one's about the person or the defendants themselves. You need to explain to me why you believe Salt Lake City Justice Court has either personal or subject matter jurisdiction on this matter.
Absolutely. It has subject matter jurisdiction because the concept was here to help it. I mean, if I could use your car analogy, I mean, just because someone lives in Alaska and he hits your car, doesn't mean you can't sue him because he lives in Alaska. Sir, I honestly looked at it and it happened here, and it wouldn't have made any sense. Because I don't even know where their addresses are, the defendants. I don't know where they reside. I don't know California. But I filed it against Justice Court because the harm happened here on March 21st. And that's why
Okay.
I felt I had jurisdiction.
I understand, sir, that you are not an attorney, although it appears you are not a stranger to the litigation process. And as you might well be aware, that is something that is noted. Certainly not just positive, certainly not anything critical, but something that is noted when we have cases that are brought up maybe on multiple occasions. I understand you're not an attorney, and I'm not sure what you do for a living, but I'm sure that I don't do that. We're all expert in what we know. There is far more about jurisdiction than what happened here. Certain things regarding relationships to a state. There's certain things having to do with certain contacts that certain defendants have to have with certain jurisdictions for that jurisdiction to have power to hear a case. Just because it happened here, or whatever those allegations are, and this is not making a determination on those merits at all, at the moment at least. It's far more about than because a concert was here that I went to. Right? There needs to be both personal and subject matter jurisdiction that would allow this court to handle that case against these defendants. And I'll give you one more opportunity if you have, and if you don't know what those elements are, then it might not be a real good investment of your time to attempt this. Perhaps maybe counsel should have been here with you. But you'll need to identify why you believe this court has both subject matter and personal jurisdiction, very specifically pursuant to Utah law. And just because the concert happened is not the right criterion.
But I'm sure you're familiar with the long-arm jurisdiction, the long-arm statute. I read through that, and it said minimum contact, and even for tort conduct, it creates a minimum conduct, and I relied on that statute to file in this court. I could have easily, I don't know, if I could have filed, could have found out where they reside and filed it in their court, but it didn't really make too much sense since I was relying on the long-arm statute.
Well, again, the long-arm statute is a common law that is very old and has many different specific statutes to it. Sir, we're talking about things of substantial activity, continuous activity, allegations that would would cause a defendant to believe that they might be pulled into a lawsuit in this state. Not only because of the subject matter of the allegations, which again I'm not really sure what the allegations are. I understand what you've said. I have not narrowed that down really very well. But also to the person themselves, to the people that you're suing themselves. In your documents, you need to make specific allegations and specific facts that would lend the court to determine that both personal and subject matter jurisdiction are proper in the case. Now, as far as the failure to state a claim, what that means is we haven't identified this cause of action that we're talking about. The you started with negligence per se, which I don't really think that's what you meant. You discussed some elements of negligence. You talked about harassment. You talked about some other activity that may have happened. Sir, I'm still failing to understand exactly what law you believe and what you are relying on, or what common law, what cause of action you believe occurred that would cause a court to rule in, to be honest, for a court to even continue with discussing, if a defendant doesn't know and can't identify, especially if the court doesn't know or can identify, what are you complaining about? What law are you saying we did wrong? What common law practice do you believe we did wrong? It's very difficult to be making those decisions. That's why it's incumbent on every plaintiff to make very clear what their causes of action that they're claiming are. So I'm going to give you one more opportunity to try to explain to me. And again, I don't need facts. I don't need that right now. I need to understand what you're complaining about to see if the facts even go there. If I can't figure out what that is, then Mr. Skordas' motion about failure to state a claim upon which relief can be granted is going to be very difficult not to grant. So I'm going to give you one more opportunity, and I want to hear from Mr. Skordas. Mr. Skordas, please continue.
Yeah, so, I'm just trying to think how to say it correctly. So, Ariana Grande held a concert here, and she is in charge of all of her staff.
Let me remind you, I didn't ask you for any facts of this, and I'm not even going into all of that until I understand under what title you're believing those facts violate. If you're going to say negligence, is that what you're going to rely on? Negligence. That there is someone had a duty, they breached that duty, and it caused you some harm, and those actions caused negligence. Is that the cause of action you're relying on?
Negligence and violation of Utah code.
Okay, and that Utah code is the right and access for any individuals with disabilities, equal access and right to services or locations as anyone else. Correct?
Yeah, and it says equal rights for managers. And that's the thing, not the use of that. The legal concept that you paid for. And not fully threatened. I know you say you don't care about the general counsel, but I talked to him, the guy over the visit home arena. He said he had no other complaints of it. And he said that the people I encountered worked for Ariana Grande.
Okay, good. Then tell me about in what manner did you what exact issues and facts occurred that made you feel threatened?
Okay, absolutely.
Bullet points, quick bullet points.
When I was at the question and answer, I was sitting in the third row. There were three guys looking right at me. They were laughing. And they're like, is he dumb or is he drunk?
How did that make you feel threatened? Threatened means you feel you are going to be hurt, you're going to be assaulted, you're going to be in some way. How did you feel threatened by that, if indeed that occurred?
As they're looking at me, they're talking amongst themselves. They didn't put too much close to me. I felt they were going to come over to me. And Ariana was sitting on the stage, and she was going for her cards. And I wanted to ask her a question. And I felt that if I stood up, because I appeared to be a certain way, they would apprehend me because I looked intoxicated or whatever. And that is the honest truth. And when later on at 10 o'clock at night, I was filming, I have a video on my phone, I was right next to the stage. The stage was like in the form of an eye. So I far end catwalk eye, and I was at the far end of the eye. And I was filming, and a car was driving my shoulder, and he was like, "Where's your seat at?" And I was trying to tell him that that was my area right there. And he turned me around, and finally the car. So there's another car standing in front of the stage. He basically had to say, "Look, this is the guy's seat." It was a very hurtful, threatening.
Someone asking you where your seat was and another person saying this is his seat, that was hurting, that was hurtful and threatening.
It was a threat. I felt threatened. I was scared. What made it worse, it was so loud. Here's this random guy grabbing me. What did I do to you to grab me? And and also when I met Ariana Grande, I felt as if she looked down upon me. I had dressed in a suit, I had looked really nice hair, and I told her I got her flowers.
And what cause of action would you say that would be violated? She had some duty to do something different than how you felt she was treating you?
Intentional I felt that it was outrageous conduct for her to basically degrade someone to pay all that money. And see, here's the thing, I heard her interactions before I even met her. She said one time, "Oh, you're so handsome," and she was nice to all these other people. I walked in there, and I had evidence in my bag of medicine I could take and to help my depression. And honestly, do I know why I post such wacky stuff, stupid stuff on my Facebook? Because I've been having a meltdown. It's been going on now. It's just been hurts.
All right.
And
Right, so I understand what you're stating. There's a security guard situation about your seat. There was something to the effect of while you were at the question and answer, and at the time that you met the artist, you felt she looked down upon you. Anything else that you'd like to add that would support these? It appears negligence. It also appears intentional infliction of emotional distress, perhaps harassment. Any other facts that you'd like to add further from Mr. Skordas to make a ruling on the case?
absolutely. So I know Mr. Skordas is going to say.
Don't worry about what Mr. Skordas is going to say. He'll say what he wants to say. I want you to tell me what you're going to say.
So, two aggravating factors to help my case. NHL was whole plaintiff. So, harm that usually wouldn't matter that much. The regular person really screwed me up. And second of all, there's an obsession with emotional distress. I know in case law, they say that usually insults aren't enough for a kind of emotional distress. But with imitators, commentators, and I've had looked, there's some broadening to allow business people who act in an insulting manner to have a claim of emotional distress with their insults. For instance, as I was researching this case, there was a really famous law professor who said that, for instance, a passenger gets into a taxi cab, and the taxi driver says, "Put out the phone," In any other situation, concerts would want to have playing, but since you're the common carrier, that's the aggravating. And there's also another exception. It was repeated conduct. When conduct is repeated, mere insults is enough to state a claim of emotional distress. But
So you would state this is some sort of repeated conduct that happened to you?
yes, sir. With different cards and
Excuse me?
with the people that work for her, yes.
Well, what if it's repeated with the entire aggregate of the situation, not with either parties or one particular individual union required?
Yes.
All right, very good. Why don't you have a seat, Mr. Greer? Skordas, I've given Mr. Greer as much latitude as I can to try to understand the cause of action about what you have, as well as discuss some jurisdictional criteria that are necessary, and only if I get past those three considerations, some surface factual matters, I would like you to, if you would please reply to the at least the responses that were included in your motion, the failure to state a claim, and the lack of personal jurisdiction.
I'd like to do one other thing, Your Honor. I'd like the court to take a look at a post that Mr. Greer made 7 days after the concert. And I'll indicate that it says, Russ Greer, smiley face, whatever they're called, anaconda, feeling happy. Dreams do come true. Exclamation point, exclamation point, exclamation point. All caps. Smiley face, smiley face, smiley face. I met Ariana Grande. I gave her my flowers and my song. I just waited for this to progress. And it's a picture of the two of them together, with her smiling and him standing next to her. So for him to come in here today, Your Honor, and say that he pressed a week earlier, that he felt demeaned by her or anyone in her staff a week earlier, absolutely negated by his own writing.
Mr. Greer, seeing this? You know what this is, Mr. Greer?
I am. I want.
Okay, have a seat, sir. You had your time to talk. You don't talk unless I ask you to. Thank you, sir. Go ahead, Mr. Schwartz.
I mean, I don't know what else to say. I mean, this case is brought in bad faith. There's no truth to his allegations. There's no substantiation to his allegations. He enjoyed the benefit of the concert. I'm sorry he has a perceived disability. And I'm sorry that he suffered through that. I'm sure that that's been difficult for him in his lifetime. But none of that has to do with our client. There's been no claim here with respect to her agent in the meeting. It appears that she gave him everything that he paid for, a backstage pass, a personal picture with him, a very, very good concert, an opportunity for him to, a week later, describe how absolutely overjoyed he was by the entire experience, and then coming in here months later and deciding that he somehow has a cause of action against her. I think, Your Honor, it's just ridiculous.
Can you tell me, through Mr. Greer's discussion, did you identify, did his discussion with us alleviate or answer your questions about what claim he is making on the EP's life? Were you able to claim that?
I don't think that he's articulated any claim.
He says something about negligence, that there were some duties that were perhaps breached.
He went to the concert, he got everything he asked for. And he hasn't described anything, I'm sorry, Your Honor.
No, it's okay, go ahead.
That relates to either of the clients here. He went to some pre-concert event, felt that he was somehow disrespected by that, but not by anyone that's being sued today. And in fact, immediately after the concert, he says what a great time he had. I mean, it's just absurd to me, Your Honor, for him to come in here today and say that somehow something happened at that event that's caused him stress. Or that he,
Do you have any sort of speculation upon, is there some, what's the reason for this then? Any speculation on that? Why are we here?
So he can get some attention. So he can have his.
Did he think these
50 minutes of fame?
Did you think these individuals were going to be here?
Of course, he thought that he would be able to, I mean, he repeatedly said that all he wants is an apology. The last case we had here, all he wanted was a date, and he would dismiss the case. He's posted here that he's going to kick my ass today in court. You know, what kind of person does that? And I would just ask, Your Honor, I would give this case, and I appreciate you, be patient, but far more time than it deserved. I would ask you to dismiss it and award us costs for defending this bad faith action.
Very good, thank you, Mr. Skordas. Mr. Greer, I'm going to ask you two very pointed questions, and you're going to answer those questions and those questions only. How do you explain, stand up, sir, and take the podium right, when I'm speaking to you. How do you explain 7 days later, happy, emoticon, people, what are those, teddy bears? I don't know. Things. If you suffered so much, suffered this emotional trauma, and intentional infliction that you had. Explain this to me.
Exactly. I appreciate Mr. Skordas doing that confidential because that was a misunderstood event, and he completely twisted the great thing.
I'm asking you one pointed question, and I'm actually giving you the benefit of even asking any more questions. So I'll tell you that if I don't get the answer, if we're straying, then I'll just not have you talk anymore. So I'll ask you one more time. Explain this post of happiness and elation. Explain this post of happiness and elation, if indeed what you're telling me is you had these certain effects upon you emotionally after the concert. How did we get to this?
Can I have a bailiff?
Okay, explain it to me, and then I'll look at what you got.
I did not want to repeat what happened with Taylor Swift. I did not want to make this a bad situation. So, yes, all that stuff happened that I told you about is true. But I decided to try and make the best out of it. Yeah, it was cool. I let her. But she treated me like crap. She couldn't wear gloves.
Do you understand how that is completely different from what you're saying to the world and all your following people?
I do, and
You understand how that those two things don't jive, those two things don't make sense. And when a judge looks at evidence, we try to understand what evidence lines up with certain claims that are being made, and sir, that doesn't line up with your claim. This sounds like, had a great time, had a nice picture, doesn't look like he's looking down on your dream. Dreams come true. That doesn't sort of align with, I felt very maligned and looked down upon in things, and now 2-3 months later, we want to sue people.
well, actually 2 weeks after I posted that post, I came out and said, you know what? It actually wasn't a good time. I was trying to hide it. That's all I'm saying.
So 2 weeks later, you decided this emotional expression was not an accurate.
Basically.
Why are you making threats to attorneys and families? Why are you doing that? Where do you think that's going to get you?
Sir, if I ever made a threat, it wasn't on purpose.
So you accidentally said you were going to be kicking someone's ass.
Can I see a reference to when I said that?
Are you stating that didn't happen, sir?
I-
Because I don't have time to be checking references.
Yeah.
If I find a reference and you made me go 10 minutes to look for a reference, I'm going to make you spend 10 minutes in the cell.
Okay.
So, do you remember what we're talking about now?
Yes, I do.
Well, why are you making me go to a reference? Why would you say something like that? Where would you think that would get you some benefit in a court of law, much less society in general? Where would that get you benefit today?
The only 2 aspects of the second is I sent an email to the manager 2 days ago saying, here's my class, replied. And then the other reference, I didn't actually name as a friend. It's like, It's a figure of speech. It's saying,
It's like saying there'll be blood in the courtroom today.
how,
Figure of speech. Is that what you mean?
I know how that can sound bad, but sir, I did not pose a threat to anybody. I hold a full-time job.
Mr. Skordas, do you have it? Let me look. Because if it is as blatant as it appears, and I'm going to put it in evidence, thank you, sir. Mr. Greer, I'm going to have difficulty. Sorry. I'm ready to knock a lawyer on his ass with my evidence. Right?
Yeah, I have evidence, sir.
It's not what we're talking about. I've given you the opportunity to talk about your evidence, about why you think there's even a cause of action, why you think this is the right courtroom. I've even entertained some of the basic factual allegations that you've made of why you may have some claim. Now what I'm asking you, and again, I had two questions. One was why these posts don't seem to align with what you're saying. But number two, where the benefit comes, you think, and why you don't think that would come to light in a courtroom about making threats to people, threats to their families, threats to what's going to happen in a courtroom. Where you might think that might benefit you. Or maybe where you think that would be proper. Do you think that that's proper?
I think it's stupid.
You think it's stupid?
It was taken out of context.
So if it was in context, it'd be perfectly fine?
So if it's saying for words, then with my awesome evidence, I'm gonna win the court case. So I guess that's.
You don't see any difference between that and I'm going to kick lawyer's ass with my evidence. You don't see anything different there.
I see how it looks wrong.
Okay, good. I'm glad that you do. And
But
you
how-
see that there's probably some other way of saying, trust me, there will be blood. You believe me and you agree with me. There's probably a different way of saying that if you're trying to say something.
Yeah.
Have a seat, Mr. Mayor. I'm ready to make my ruling. I've given all the information and all the information, as much consideration as I can, and due amount of time on this case, but I wanted to handle it completely and accurately. In my estimation, there are 4 elements that are either at issue or being disputed. We start off with the matter of jurisdiction, both personal and subject matter jurisdiction. Individuals that come through town for a night, perform a concert or a rodeo or a monster truck jam, are not availing themselves to our state. They are not continuous, they are not consistent. Not only is that subject matter of that event, by its very nature, not subject matter jurisdiction, the individuals that are defendants must have some personal jurisdiction, have availed themselves, have minimum contacts, at least to a consistent and stable basis for them to avail themselves to the court system of a particular state. I don't find that this defendant, or her agent certainly, have availed themselves to the state of Utah, much less this court, based on the subject matter of a concert coming to town, or personally, in either instance, on either defendant. Number one. Number two, the statement, the failure to make a claim upon which relief should be granted. I've asked the plaintiff on multiple occasions, I think I've given as much latitude as I possibly can for an explanation of what cause of action there would be. I heard different things like negligence. I heard negligence per se. I heard intentional inflictions of emotional distress. I heard harassment. Based on at least the surface information that I continue to ask the plaintiff on, What led to that? What are you saying that led to negligence or harassment? I heard things that I felt if I got up, I would be threatened or I would be assaulted. Subjectively, that appeared the plaintiff believed he was afraid, or he was scared, that he believed he was degraded. I'm not sure what duty the plaintiff believes that artists of international nature have, much less artists of local nature have to anyone. And as it does not appear to be in dispute that the events or the occurrences upon which the plaintiff contracted or purchased tickets or passes or what have you, it does not appear to be a dispute that happened. I'm looking at a picture of it happening. I'm looking at posts confirming that it happened. Mr. Greer's own testimony about being in a question and answer, wanting to ask a question, meeting this artist, being sort of right on the front row of the staging. It certainly appears that, and I don't know exactly upon which Mr. Greer contracted, but it sounds like he got what he contracted for. I don't know that that contract is that I'll accept your flowers and play your song, or even be super nice. I don't know. I don't think so. So I don't see negligence. I don't see harassment, certainly by the two defendants. Perhaps if there was a security guard, a named person, or somebody of that nature, but the vicarious nature of negligent responsibility all the way up to a named artist is not proper or allowed by our law whatsoever. So I don't see harassment. I certainly don't see any negligence. I spent the time on this to go through this very carefully so that Mr. Greer understood that the ruling behind this today. I'm denying Mr. Greer's claims for relief that he's made in his affidavit summons. Denying his reimbursement of fees, service costs, and any other costs. Pursuant to my discretion, Utah law, I have to make a determination if this was brought in bad faith. If this was a non-meritorious claim. If this was only here to harass, to annoy, for ulterior purposes. And I find that that is the case. I might understand. I have no reason to disbelieve. I don't know Mr. Greer. If he subjectively believes he had a certain rights and duties owed to him, that may be true. You might believe you do. That doesn't mean it's true. You don't have those rights. And bringing a lawsuit, and again, not that this weighs on the on this case, but the court certainly considers repetitive litigious nature of a plaintiff. It does appear that this is not the first time this has happened. Based on the repeated nature of that, the claims that have been made, and unfortunately the failure to state a claim that can be even granted, even if I did believe that there was something nefarious or inappropriate that went on, I don't find that this claim is brought in good faith. I do believe that it has no merit. Before you came, Mr. Greer, 35 minutes late, I asked Mr. Skordas the type of fees that he has incurred on this. Based on my discretion, pursuant to Utah law, I'm awarding $1,500 of attorney's fees to defendants for their time incurred expenses to defend this non-meritorious action. That is my ruling for the day. You might not like it, Mr. Greer, but do you have any questions? Mr. Skordas, you might not like this. Do you have any questions? Very good. That will be the disposition of this case.